And welcome back to Talking Law TV. I'm Michael Short, and we're here with Christie Register. Hi, Christie.
Hey, Michael.
We're here to talk about the process of a personal injury claim.
Yes.
So I imagine all that starts with getting all the right documents.
It does. Obviously, after taking care of everything at the accident scene, getting medical help if you need that, the next step is to start getting the documents, first being the accident report. That'll give you the insurance information that you need.
Do they try really hard sometimes to keep you from getting the right documents?
Well, you know, often the tortfeasor, the person who caused the accident, will give the officer a card, and that may not be the right card, so that may not be the right policy, or that policy may have just been canceled. Now, understand that officers can now they verify that you've got insurance, and you know, when a policy cancels, it'll be reflected on the person's insurance card and the vehicle. So that's a safety net, but sometimes it's not the right information, and we have to dig until we get the correct information.
What happens if the person, as we've learned on other episodes, a third of drivers don't even have insurance? So are you going after their house?
You can, but most people that don't have insurance don't have a house. Most people that have things to be protected will have insurance. You know, auto insurance is not that expensive, so if you've got somebody who's driving around uninsured, chances are they don't have anything to get.
And there's another reason for uninsured motorists.
Exactly.
Now, if you have, I know this is off our topic, but if you have uninsured motorists, you're not going to, you're just going to get fixed. You're not going to get any damages, are you?
Incorrect.
Tell me why.
Because uninsured motorist coverage takes the place of the liability policy that the person who hit you did not have. So the same damages that you could have gotten from the insurance policy of the tortfeasor, you get from your uninsured motorist, including pain and suffering, medical bills, any scarring, permanent injury, anything like that.
Does that mean that you have to sue your own company?
Yes. You do. You sue the defendant, the person who caused the accident, but you serve your uninsured motorist insurance company, and that's why you have it. You know, they work with you. It's still an adversarial process, but you know, they know if you prove to them that the person who hit you did not have insurance, then they know that they have to step up and resolve the claim.
Okay. Now, let's assume that they do have insurance. Is it always necessary to file the lawsuit to get your damages collected?
No. You can get it resolved without filing a lawsuit, without ever stepping foot in a courtroom, if the insurance company will be reasonable. And more often than not, they are. You know, auto accidents, most of them are clear liability. It's obvious who was at fault. The challenge is proving the amount of damages. So the insurance company is, okay, yes, we owe you something. Their goal is to pay you as little as possible. Of course, our goal is to get you as much as possible, and that's where the fight begins with the numbers. You know,
the common thought is, of course, the insurance companies are represented by defense firms, typically not probably lawyers on staff. The defense firms are paid by the hour, so it seems like it's in their best interest to draw it out.
Yeah, it does.
I mean, why? You know, they make more money if they take forever.
Yeah, they do. And if that's why it's always better if we can get it settled for a great result. It's better to get it settled. It's faster, it's less expensive. However, if, you know, frequently I'll have an adjuster, they're just not being reasonable, and, you know, I talk with my client and say, hey, if I were you, let's sue them. Let's get it in suit and just see, because often they'll take you seriously at that point. And if you've got a difficult adjuster, then you can get into the hands of a defense lawyer who knows the system, and they know what they're looking at with a verdict. But yeah, often getting another lawyer involved does complicate things. And out of fairness, they have to get familiar with the case, and they want to do a good job. You know, they've got a duty, but it certainly drags things out.
Yeah, is that when you get mad enough to say, I'll just see you in court and hang up the phone?
I have never done that. You know, it's always better if you can get it resolved outside of the courtroom. So I try my very hardest not to do that. And with some people, yes, eventually you're like, they're not going to be reasonable. Let's go see what a jury says. So sometimes you come to that point.
But you want to do it sometimes, don't you?
Oh, yeah. Definitely you want to do it. You just don't.
So if that doesn't happen, now what happens? How do you get the lawsuit served, and what's the next process?
The attorney drafts a complaint or a lawsuit, files it within the proper court, and then the sheriff's deputies serve the defendant if the defendant won't accept service, and then that gets the ball rolling. They've got 30 days to answer. That's the period of discovery where each party gets to ask each other questions, written questions, get to depose each other, get medical records. It gets fairly lengthy, but often after you file the lawsuit, do some discovery, you can get the claim settled at that point.
Well, you recently had a case where the person was in the hospital for almost 3 months.
Mm-hmm.
What point do you start the process? Do you have to wait till they're out?
You don't have to. It depends on the policy limit that you have. My sweet lady that was in the hospital for 3 months, if the person that hit her had a policy limit of $100,000, I would have gotten it like that, because her bills were way more than that, and the insurance adjuster would have known it. In this case, there was a high policy limit, so we want to wait till she gets out of the hospital, gets all of her bills. If she needs to have more surgery, physical therapy, anything like that, we want credit for all of those bills and surgery. So you would want to take your time if you've got a high policy where it's not obvious that they should pay the limits.
Okay.
It's complicated.
So if you sue them now, you've got their attention. Is it still too late to settle, or do we still go to court?
No, you can settle at any point. You know, often cases settle in court. I've even had friends who have tried the whole case. You know, the case has been presented to the jury, they're deliberating, and the parties reach a settlement. And say, okay, stop, jury, we've decided. So, you know, until the jury reads the verdict, the case can be settled.
What are some of the methods that you use? Because I know this one term I've heard called high-low.
Yes.
How is that used?
That's kind of like an insurance policy. If you're going to a jury, both sides are at risk of losing. The plaintiff, or the person who got injured, is at risk of getting zero or less than what has been offered. The defendant is at risk, or the insurance company, whomever, of getting a high verdict against them. So sometimes the parties will reach an agreement that will say, okay, no matter what the jury says, the lowest amount the plaintiff can get is $50,000. The highest amount the plaintiff can get is $500,000. So even if the jury returns a verdict of $800,000, you only pay $500,000. So it's an insurance policy, basically.
And you agree to that before you start?
If you want to. Obviously, as a plaintiff, if we've got a super strong case, then you would never do that.
Okay. Well, thank you so much, Christie.
Thank you
for enlightening us on this. And
Certainly.
if anybody out there has any questions about personal injury claims, they can reach Christie through our website at talkinglawtv.com, or through our toll-free number at 888-203-7-LAW. We'll be back with Doug Andrews in part 2 of the Intoxilizer 5000 right after this.